existing claim. So the
defendant in their briefing indicates that, I'm sorry, I guess the plaintiff in their briefing indicates that, as I understand their argument, that claims continue for 3 years after the corporate charter is forfeited, correct?
If that was directed to me, Your Honor, that's correct. What was cited is part of the provision, but not all of it, as you noted from our brief.
Okay. Oh, I think Mr. Yezagara just dropped off.
I apologize, Your Honor. I had a pop-up and I exited out and
It's all right. Those things happen.
no, I'm sorry.
What I was asking is in the briefing for the plaintiff, they indicate that when you have a corporate charter forfeited, that there is a kind of 3-year grace period, which apparently this claim was filed within. Do you have any cases that indicate if you have a corporate charter that's forfeited during that time period that it would end all claims or somehow be relevant to a venue determination?
Yeah, Your Honor, I didn't see any cases on along those lines. I was just just basing our argument off the statutory language. I didn't see case law on that.
Okay. Did you have anything else?
That's the sum of our argument, Your Honor. As far as where the events and omissions that give rise to plaintiff's claims occurred, we also think that just not only in their allegations, but in all the invoices that were attached, it's clear that the equipment that was the basis of the contract was all leased in Hidalgo County. It was picked up in Hidalgo County, maintained in Hidalgo County. It was used exclusively in Hidalgo County. There are allegations that the property was damaged. I think that's really why the invoices are so high, because of the cost to repair the equipment. Any alleged damage that occurred to the equipment occurred in Hidalgo County. It was repaired in Hidalgo County. And if there was a debt that was incurred by my clients, it was incurred in Hidalgo County. So based on all that, we're asking for venue to be transferred to Hidalgo County. The LLC that is my client, Philagonia Materials, is still forfeited. So what the plaintiffs did, I believe, was actually correct. They sued the two Cepeda brothers because the LLC doesn't exist. So that's kind of their remedy, is to go after the individuals and dismiss Philagonia Materials and move it all down to Hidalgo County, because the individuals were not parties to that venue provision.
Response.
Thank you, Your Honor. And obviously you read everything, so I'll keep it as brief as possible. Obviously the venue provision's out there. And the larger point is that the plaintiff's choice of venue here should stand, and it under Texas law, our choice of venue controls, unless there's something else that they can show that it shouldn't. And all of our venue facts have to be taken as true per the Civil Rule of Procedure 87 and Supreme Court of Texas law. Based on all of that, our assessment here is that A, that the venue provision should control, B, that they have not shown that no substantial part of the events giving rise to the claims occurred in Dallas County, which is the standard, or that they have likewise not shown that the balance of justice predominates in favor of the action being brought in Hidalgo County. And just very briefly, you obviously know about the venue provision. I don't need to belabor that. I will note that the big piece of their briefing relies on the idea that Philagonia is not a valid party. We cited, I think, at least 4 cases showing it's very common practice to sue the terminated entity and any guarantors. The part of the code that we cited that allows for liability to be imputed to the individuals does not absolve the company. And in fact, that part of the Texas Business Organizations Code contemplates what happens if a company gets reinstated. And obviously here, even the defendants have stated they're trying to reinstate Philagonia. We want a judgment against everybody. Because if Philagonia comes back into the fold, we want to be able to assert our judgment and collect our judgment from all liable defendants, and that includes Philagonia. Likewise, this is not a motion to transfer venue. The existence of a cause of action is immune from a challenge at the venue hearing. That's per Texas Rule of Civil Procedure 87 2B. Also, there is precedential law on this that says that we have to assume all the facts and all the claims are valid. With that said, the claims against Philagonia being valid, this venue provision should apply. Likewise, the binding precedent on this court says the court's initial inquiry is whether the defendant challenging the venue proves there is no substantial connection between the plaintiff's claim and chosen venue, not whether it proves a substantial connection to an alternative county. And we cite that in our brief, as you read, Your Honor. We made the contract, my client made the contract out of Dallas. It calls for performance in Dallas, specifically payment. That performance was breached in Dallas because it was not paid in Dallas. Likewise, even putting aside this contract, the invoices that the two individual defendants attached to their own motion say at the bottom that all payments to Romco must be, all payments shall be payable in Dallas County, Texas. So the terms that they agreed to in the invoices that they got, and they kept ordering after they got the first invoice with that term on there, also calls for performance in Dallas. So it's very clear that there is a connection to Dallas, very clearly. And they were unable to prove that there was no connection to Dallas. Now, the last 2 points I'll make are that there is precedent from the Supreme Court of Texas that says Texas courts in making venue determinations in breach of contract cases have considered where the contract was made, performed, and breached. Like I just said, Romco made the contract in Texas, sent it from Texas, issued the equipment out of Texas. It was breached in Dallas because it was not paid in Dallas. So we think that that also is another reason it should be in Dallas. The last 2 points I will briefly make are that they have to show that all 3 elements, that it would work an injustice to them. And then number 2 is that the balance of interest of all parties predominates in favor of the action being brought in another county, and that the transfer would not work an injustice to my client. They've given no specific evidence about hardship, and Rule 87 says that affidavits can be used, but they, quote, shall set forth specific facts that would be admissible in evidence. What I saw was very conclusory statements that it would work a hardship, but no specifics. Defendants also don't identify any witnesses or estimate how many they may call, but they assert conclusory that virtually all witnesses are in Hidalgo County. We would dispute that in that most of the witnesses would probably be our people talking about the non-payment, and they're in Dallas County, and the affidavit we attached proves that. Also, they admitted that the custodian of records for our client is also in Dallas County, so it's not exactly true that the witnesses would all be in Hidalgo. In fact, only 2 of them would be. And I don't know that we would even need their testimony. And lastly, Your Honor, it's unclear. They don't address how it predominates in favor of being in Hidalgo County, just that it would be more convenient. And they don't explain why it would not work an injustice on my client, who's already out quite a bit of money chasing this down. And the argument that we contracted with somebody in Hidalgo and therefore that's enough, I think that's not only doesn't satisfy the standard, in my opinion, but respectfully, it also isn't a very strong argument because they reached out to our client in Dallas and contracted in Dallas. So if we're going about where somebody contracted for venue, they contracted in Dallas. That's all I have, Your Honor, pending your questions. We already touched on the right that Philagonia does exist for the purpose of this lawsuit per the statute, so I won't belabor that.
All right, I'm going to go ahead and deny the motion to transfer venue. Anything else we need to chat about today? And one thing I will say is, just so you know it, and I'm not sure how to say your last. Is it Yuzag? How do you say your last name? Yuzagira?
Izagiri is fine, Judge.
Sorry, I'm from South Texas too, so grew up in Corpus Christi. What I will say is to try to make this a little bit less onerous for you is that on our dockets on Monday are remote. So if you need to set any hearings, I'd ask you, Mr. Webster, to kind of work with Mr. Izageta to make sure that the hearings he said are on Mondays. Our Friday dockets in person. There's no reason to make him come up here unnecessarily. And I don't know if this is going to be a jury or non-jury trial, but my non-jury trials are also remote, so you wouldn't necessarily have to come here. Your clients would have to come here. If it's not jury, if it's jury, we're doing those in person.
I appreciate that, Your Honor.
All right.
In your honor, if I was to set a dispositive motion, I'd be happy to set it virtually. Is that something I could also do for Monday to help out all the parties?
Yeah, on any Monday, yes.
I will do my best to do that to help as much as I can.
All right. Thank you so much.
Thank you. Maybe be dismissed.
You may. Have a great rest of your day.
Thank you, Your Honor.
Let me just take a look at something. Is anyone here on the McNack versus Barber case? McNack v. Barber. I see some folks here. Let me see. Anyone? Rhonda, can you come in here real quick? Mr. Graham, what are you here for?
Good morning, Judge. I'm here for the defendant in Shake Snyder versus Martin Marietta. It's cause number DC 22-05485.
Is that on the dismissal docket, or what are you here for?
We got a notice of hearing, Your Honor, for a scheduling conference, but since then the court has entered an agreed scheduling order, so I just didn't want to no-show the hearing.
You don't need to be here. Thank you so much.
Thank you.
Have a rest of your day. Give me 1 second. Okay. Mr. Sweeney, what are you here for?
I'm here. I represent Patricia Aldrich. It's Richardson versus Aldrich. We have a scheduling conference this morning at 10.
I see it. Okay. It's the other side here.
I do not see him on my screen.
Okay. Well, it's not 10 o'clock yet. So are both sides here on the Megan Meeks Francis versus DDM Construction Corporation case?
Judge, this is Trey Camper on behalf of DDM. I talked with Mr. Sorrells, who represents the plaintiffs, and he said that someone's going to be sitting in on today's hearing for him.
That's me.
Okay.
Good morning.
Good morning.
And Your Honor, my name is Josh Weems. I'm here for the other defendant on that Francis v. DDM Construction Meat Servicing Group. So I think we have everybody here.
Okay. Who's here, counsel for plaintiff?
Jessica Rodriguez Walquist covering for Randy Sorrells.
Okay. All right, guys. Do you guys have an agreed scheduling order, or what are the issues if we don't?
Judge, I spoke with Mr. Sorrells this morning, and we're in the process of coordinating an agreed scheduling order. I believe that we discussed setting this case for trial sometime within the next 11 to 13 months. And we were just going to work backwards from that trial setting.
Let's pick a date, and then you guys can work out the scheduling order. So I'll pull that up. So you're looking at sometime next September to November, approximately.
Yes, Judge.
Yes, sir. My understanding of what he told me is that he was looking for something between October and November due to other conflicts that he has.
Okay, let me take a look at it. We're pretty open at this point in October 2023. Let's see. Rhonda, can you bring me the 2023 jury? Oh, wait a minute, it's on here. Yeah, so we're pretty open. November 7th is a non-jury day, but other than that, we're pretty open. So when would you like to be set? We have the 3rd, the 10th, the 17th, the 24th, the 31st. October 7th is a non-jury day, or November 14th.
The 13th of November works for me, Judge. So
14th, it's the 14th of November. We start trial on Tuesday.
okay, that works for me as well. And then
is this going to be a jury, non-jury?
Jury trial, Judge.
How long will it take to try?
I wouldn't anticipate more than 3 to 4 days.
Only issue I have with the 14th is the next week is Thanksgiving.
Mm-hmm. Yeah, that's generally bad. October 30th or the 31st of October also works.
I would very much prefer not to start a jury trial on Halloween, if we could avoid it.
Okay.
Basically, I'm free on all those days, Judge. So I'll let Ms. Rodriguez select whatever date works best for Mr. Sorrell's calendar, and then let Josh chime in.
Yeah, Josh, we don't have any objection as to any October, November date, so.
All right. So how about October the 17th, guys?
That work for you?
Good deal.
Okay, let's pick a mediator. What do you guys like?
Great.
Judge, could we, pending, if we can't agree on a mediator, then
Do it later. So what now? So who do you guys want to use?
Anybody have any objection to Jim Juno?
Jim Juno? Jim Juno's great. You guys like Jim Juno?
that works.
Ms. Rodriguez?
That's fine, Your Honor.
All right. So we're going to set this for trial on October 17th, and the mediator will be Jim Juno. If you guys want to substitute someone else in, that's fine. Anything else we need to chat about? Any other issues? The main thing I like to have in there is that any dispositive motions are heard at least 30 days in advance of trial.
Okay.
But anything else you guys need to chat about?
I don't think so, Your Honor.
Ms. Rodriguez,
No, Your Honor. Thank you so much for your time.
Mr. Kemper.
No, sir.
All right, you guys have a gregreat rest of your day. We'll get a scheduling order, or we'll get a trial setting notice out and a mediation order out. You guys just get a read scheduling order when you can.
Thank you, Judge.
Judge.
Guys, all right. Anyone else here on the scheduling conference docket? Let's see.
Your Honor, I'm here for Richardson versus Aldrich.
And I see Mr. Bavafa is here as well. So let's go ahead and have you guys come up with the trial date yet?
We have not, Mr. Bavaha. Just I recently received notice of his designation of lead counsel.
Okay.
If we could get a trial date a year out, that would be great. We have not mediated the case, and we still do have. We're waiting on subpoenas and have some additional depositions that need to be taken.
Yes, Your Honor, I concur. A year out is a conservative estimate.
You want to shoot for October 3rd, 10th, 17th, 24th, 31st?
Bear with me, Your Honor.
Sure.
Sorry, the court mentioned October.
We set trials on Tuesday, so 3rd, 10th, 17th, 24th, or 31st.
Your Honor, the 24th works for me.
Okay.
Mr. Bavafa.
Yeah, if 24th works for me as well, Your Honor.
All right. And who do you guys want to use as a mediator?
Pardon me, Your Honor. Sorry, I couldn't hear you.
Who would you like to use as a mediator?
I haven't conferred with opposing counsel on this, Your Honor, but in the North Texas, I've used Mr. Leckrone a few times. I'm a little bit more familiar with the South Texas mediators and North Texas. If opposing counsel has a suggestion, I will certainly.
Mr. Leckrone, I've heard is an excellent mediator, but is Mr. Sweeney is somebody you like?
You know what? McCullough mediation is fine. Ms. Auld, A-U-L-D is fine.
You don't, you don't
I
like,
just-
oh, go ahead. I'm sorry.
I apologize for interrupting you, Your Honor. I just basically, if opposing counsel were to give me names that he prefers, I would just have to search the names. And if you were to give me a bunch, I'm sure I can find a few.
So McCullough is also very well respected. Is there someone there you like in particular, Mr. Sweeney?
Mike McCullough is good. Martin Terry is good. I like people that my client listen to. So that's why I prefer one of those two.
Okay. If I may, yes, Your Honor. You said, I'm sorry, counsel. Can you please repeat the name of the second mediator?
Martin Terry was the second. The first.
Yeah, Terry is Terry. First name is Martin, and then Mike McCullough, McCullough.
Both very experienced, well-respected mediators. So, Mr. Babaha, I'll let you choose between those two.
Okay. Yes, Your Honor. If I may I just briefly, may I do a quick little research on them?
You need to choose. McCullough heads the firm up. He's a little harder to schedule with. I don't know how big this case is, but they're both good mediators. But if you're going to practice in Dallas, you got to know the mediators. So who do you want to use?
Okay. Let me look at. Bear with me one moment, please, sir.
Mr. Sweeney, do you can't agree to Leckrone? You prefer one of these two?
That would be my preference.
I can.
Go
I'm
ahead.
sorry. No, I just did a quick search. I can use Mr. I think our firm has used Mr. Mike McCullough in the past, so I'm okay with it.
Let's use Mr. McCullough as the mediator, and we'll set this for trial on October 24th. Any other issues we need to chat about before I let you go?
No, Your Honor.
Not from my perspective at the moment, Your Honor. No.
All right, we'll go ahead and send you a scheduling order, or not a scheduling order, a trial notice. You guys can put together a great scheduling order if you want to. And then we're going to appoint Mr. McCullough, and you guys have a great rest of your day if you don't need anything else.
All right. Thanks, Judge.
Thank you, guys. Have a good day.
You
Thank
too.
you.
All right, bye-bye. Ms. Dukes, I think you're a tiny bit early.
Yes, sir, I am. I didn't want to be late or anything, so I decided to hop on early. So
No
I'm
problem.
here.
Over. What are we doing here today?
A motion hearing for alternative service by posting.
Okay, yeah, let me look that up. There's an issue with it. All right, so this is the issue with this. You want to do service by, I thought it said was publication. Is it by posting? Is that what you said?
Yes, I think we were going to do publication and then we filed for alternative service. So we might, The thing is that we've gone out to the address that we have on file multiple times, and we have the cars that were parked out there, but no one has answered, so we can't confirm that there is residents.
So what I see here is that you have the uncle's address,
Yes,
and the uncle, it doesn't show that so to me, I'd much rather you serve through alternative service by posting or
Okay.
by service of else. If you did any of the cars come back to the defendant?
okay.
You know what I'm saying? Like you said, there were a bunch of the residents.
There was, but I don't think it was the vehicle that was at issue.
No, I mean, but did any of those vehicles was the registered owner the defendant? You see what I'm saying? Like, so you have Bob Smith, and you find his car at 1000 Main. I'd much rather that be as a close enough connection to be able to get alternative service at that location, as opposed to doing service by publication. But it says there was a bunch of cars, but he didn't run. At least what I've seen, he didn't run any of those license plates to see if they were linked to the defendant. We know that the uncle lives there, so service by publication should be the very last thing you try to do, because it's so unlikely to give notice. And so I'd much rather you have service through posting if you can get some type of reasonable certainty that a reasonable likelihood, I guess, that the person will get notice. And so if the car is registered there at that address, or the car is parked at that address, and it's registered as a defendant, that to me is better than doing service by publication. Does that make sense?
Yes, sir. I'm sorry, Your Honor. We can have our process server get the license plates, so we can then run in the VINs and amend our motion if those are the cars. If not, then we'll have to look at an alternative method. Can do that, Your Honor.
And even if just the uncle is there, I'd probably rather you do service that way, serve it on the uncle, as opposed to just doing service by publication, because at least the uncle could give it to his nephew. But if you could at least run it, go out there again, try to get service, and then run the cars, that would be helpful. So, but we'll go ahead and give you an additional 30 days on this. Or actually, is this sent on the DWAP docket? Let me see.
Yes, it's on the 10th of October next week.
Why don't you want me to just reset it on the DWAP for another 30 days?
Yes, Your Honor. Be great.
Go ahead and reset this on the DWAP for an additional 30 days.
Okay.
All right. Anything else, Ms. Duke?
That's it. Thank you.
You have a great rest of your day, okay?
You too. Have a
Thank
good
you.
one. Bye.
Tony, I'll be right back. Ms. Soto,
Good morning, Your Honor.
good morning. Are you here for a hearing?
Yes, we originally scheduled the hearing. I'm here on behalf of Kinsale Insurance Company. We had scheduled the hearing on Kinsale's motion to sever and abate the coverage claims. And we received notice this morning that plaintiff does not oppose our motion, and we previously confirmed that the other parties, the defendants in this action, similarly do not oppose. Therefore, I'm happy to go through our arguments on the matter, but at this point, the motion is unopposed. Therefore, if the court would prefer that we submit a proposed order, we can certainly do that as well.
Now let's, I don't want to hear your argument. I just want to kind of chat with you about why you feel like we need to sever and abate this. I understand there's some coverage issues, and how do you anticipate this would go forward exactly?
Sure. So just as a general note, and obviously we outlined the authorities in our motion, the purpose of the severance and the abatement would be to separate out the remaining coverage claims that still exist against Kinsale, as is required under Texas Rule of Civil Procedure 38C and 51B. As you may remember, Your Honor, the court has already ruled on motions, partial motions for summary judgment in this case with respect to the duty to defend. And Kinsale is currently defending Rosewood's, JR's demolition, and the Lindemutz in this matter. Therefore, the remaining issues are the third-party claims as well as the cross claims brought by Rosewood's, JR's demolition, and the Lindemutz. And those claims are related to the duty to indemnify, as well as there are some extra contractual claims with respect to the allegations of violations of the prompt payment of claims, alleged violations of the Insurance Code, Deceptive Trade Practices Act, as well as allegations of negligence and breach of contract with respect to the coverage issues. And those matters, for the most part, in addition to the fact that the rules of civil procedure as well as several Texas appellate courts have determined that these matters are not appropriate to be joined and cannot be joined against the liability insurer with the underlying liability suit. Additionally, several of these matters may be mooted depending on the resolution of this liability suit that is presently before the court.
Okay, so so the idea is that we would abate this, and then we would sever it into a new cause number and then abate the case. Is that the idea?
Yes, Your Honor. Typically, that's the way these would be handled in previous matters where I've requested similar relief from the courts.
And okay, so you know under Texas law you're going to need to pay a severance fee. I didn't see an order that's attached here, so make sure the order also includes you'll need to request a new cause number.
Yes.
It doesn't really become effective necessarily until the severance fee is paid and the order is signed by the court and the clerk's given a new cause number. But I'll go ahead and grant the motion. Just give me an order as soon as you can that includes a blank for the cause number, and then you'll need to pay the severance fee.
Great. Thank you, Your Honor. I appreciate your time.
All right. You have a great rest of your day.